Today's a good day to be the NRA, as the United States Supreme Court just issued an order finding in their favor. Hello everyone, and welcome back to the Firearm Firm channel. I'm attorney James Phillips, and today we are going to be talking about the order that was just issued this morning by the United States Supreme Court in the case of the NRA versus Vulo. But before we dive into this ruling, please take a moment to hit that like button. And if you enjoy staying up to date on the good, the bad, and the ugly affecting your Second Amendment rights, be sure to subscribe to the Firearm Firm channel. It's real easy to do. All you have to do is hit that subscribe icon located down in the bottom right hand corner of this video where the arrows are indicating. So I previously did a video fully discussing this case, which can be viewed by clicking on the link above, or if you want to finish this video first, I will put a link to that video down in the description section. But in short, the NRA filed a lawsuit against Maria T. Vulo individually and in her former official capacity as the superintendent of the New York Department of Financial Services, DFS, along with Andrew Cuomo individually and in his official capacity as the governor of New York, because Vulo had pretty much strong-armed financial companies into not doing business with the NRA by threatening to have DFS do audits and or fine the companies. Following the motions to dismiss, the district court upheld the NRA's first count alleging an implicit censorship regime and its second count alleging retaliation against the NRA based on the content of its speech, and denied Vulo's and Cuomo's motion to dismiss those counts based on qualified immunity. Now, Vulo appealed. For some odd reason, Cuomo did not, but the Second Circuit Court of Appeals reversed the district court's denial of Vulo's motion to dismiss and remanded the case with directions to enter a judgment for Vulo, holding that the NRA failed to plead a First Amendment claim. Based almost entirely on that reasoning, it also found that Vulo was shielded by qualified immunity. Now, after the NRA's petition for an en banc rehearing was denied, the NRA filed a cert to the United States Supreme Court, and today, that U.S. Supreme Court issued a 9-0, meaning unanimous ruling, finding in favor of the NRA and reversing the Second Circuit's order. Justice Sotomayor delivered the order and wrote, Vulo was free to criticize the NRA and pursue the conceded violations of New York insurance law. She could not yield her power, however, to threaten enforcement against DFS regulated entities in order to punish or suppress the NRA's gun promotion advocacy. Because the complaint plausibly alleges that Vulo did just that, the court holds that the NRA stated a First Amendment violation. A government official can share her views freely and criticize particular beliefs, and she can do so forcefully in the hopes of persuading others to follow her lead. In doing so, she can rely on the merits and force of her ideas, the strength of her convictions, and her ability to inspire others. What she cannot do, however, is use the power of the state to punish or suppress disfavored expression. The court further noted, in sum, the complaint assessed as a whole plausibly alleges that Vulo threatened to yield her power against those refusing to aid her campaign to punish the NRA's gun promotion advocacy. If true, that violates the First Amendment. The order goes on to discuss how the United States Court of Appeals for the Second Circuit failed to properly analyze the NRA's First Amendment claims. I will put a link to the order down below for anyone wanting to read more about the legal analysis the court went through. But for those who just want to know the outcome, the U.S. Supreme Court held that the NRA plausibly alleged that Vulo violated the First Amendment by coercing DFS regulated entities to terminate their business relationships with the NRA in order to punish or suppress the NRA's advocacy. The judgment of the United States Court of Appeals for the Second Circuit is therefore vacated and the case remanded for further proceedings consistent with this opinion. Now, although this case is about the First Amendment, it is still a victory for the Second Amendment, as this case dealt with an anti-gunner politician trying to force her views on others by using her power to financially hurt companies that did not share her beliefs. Be sure to let us know what you think about this order down below in the comments section, along with any questions you have about this video or any other Second Amendment related question. Until next time, stay armed and educated.